Hey, everybody, it's Thursday night. Hey, everybody, John Skiba here with the Consumer Warrior YouTube channel. Thank you for checking in once again each and every Thursday night. Here we're to discuss all things debt related, whether it's debt collection lawsuits, bankruptcy, debt settlement, all those types of things. That's why I started this whole YouTube channel, was to help to provide some tips and guidance and some resources for people who are dealing with serious debt problems and how to get out of them once and for all. I am a licensed attorney in the state of Arizona. However, I'm not licensed anywhere else. So if you need legal advice, this is not the place to go. You need to talk to an attorney in your state. If you are in the state of Arizona, my contact information is below. I do free consultations on bankruptcy and defending debt collection lawsuits. I'd be happy to see how I can help you out. That's the name of the law firm I work at, up there in the upper left-hand corner, Jackson White, here located in Mesa, Arizona. So how we do this is, if you're on YouTube, you can put comments in the section there, and we'll go ahead and put them up on the screen, and we'll discuss it. Like I said, I can point you in some right directions of ways that you may be able to deal with some of these debt collection issues. Before we jump into it, I just want to remind everybody I have started this new Consumer Warrior community, which is an online platform to allow kind of deeper discussion. I'm also doing members only videos and trainings. So like this past week, we just did one. I'm calling them master classes. I did one on excluding debt buyer documents as hearsay. If you join the Consumer Warrior community, that one is already, the recordings there, the handouts are there that I did. And then this coming Monday evening, I'm going to be doing a masterclass on how to cross-examine a witness, just like Tom Cruise. We're going to do that, and I'm going to provide those who attend that and who are members of the community. I'll provide them with the script that I use, a list of questions when I'm cross-examining a junk debt buyer witness. So that's a great way to kind of get a deeper understanding, particularly with the defending of debt collection lawsuits, as far as how to deal with them. And if you want to sign up, if you look there in the comments section at the top, there's a link not only to all my tutorials, but a link where you can sign up for that community. So starting off today, I wanted to go over, there's one question that I liked. I don't know if I saved it. Let me see. I don't think I did. Well, one of the questions was that was on the comment section was whether you need to include cryptocurrency if you're filing for bankruptcy, if you need to disclose that. And I had brought this up last week, but I found a screenshot I wanted to show you. The answer is yes, you do. But this is Coinbase, who's one of the bigger crypto wallets. I don't know what you call them. But Coinbase has its own bankruptcy trustee guide on its website that helps trustees to be able to locate accounts. And if you look right down in here, it provides account information, balances, and transaction histories. So they can show whether money's coming in or out. And so the crypto world is kind of a whole new, brave new thing these days, but it is something absolutely that has to be disclosed in your bankruptcy filing as an asset. And frankly, it's a felony not to. So it's important that if you are filing for bankruptcy and you have cryptocurrency, you need to disclose that to your attorney so that it can be adequately put in your documentation. All right, let's jump into the questions. We got Al here, not only supporting the channel like he does each and every week, but says, success, the court dismissed my Midland suit. It was without prejudice, but a win still a win. Thanks for the videos, tutorials, live streams. They're a huge help. Awesome. I'm grateful you're able to get that done, get that thing thrown out, and move on with life. Again, if a case gets dismissed without prejudice, it means that it can be refiled. I'd be interested to hear why they dismissed it, because depending on the reason it was dismissed, even if it's dismissed without prejudice, again, meaning that it can be refiled, a lot of times they don't. So, Al, congratulations on that. All right, let's see what Mike says. Mike says, I filed a motion to dismiss and compel arbitration. Debt buyer didn't show, and the judge dismissed the case without prejudice. Can the debt buyer still pull me into arbitration? Likely they'll refile or require arbitration. I read the arbitration option evaporates for the debt buyer if they pursue the case in civil court. So, as far as your questions here, can they still pull you into arbitration? They could. I'm going to tell you, they don't want to be in arbitration. That's why usually you'll see when you file a motion to dismiss, they either don't show up to contest it, or they do. Sometimes I file them and they'll fight me, try to tooth and nail to keep it in court. They don't want to go through the arbitration process. So if I were, betting on this, I would say I don't see them bringing you into arbitration. The more likely thing is they could refile it, I guess. But the thing that they have to look at now that it's been dismissed, is the statute of limitations. The amount of time that the state law allows a creditor to bring a claim from the time it goes into default. Like in Arizona, it's 6 years. They have to file the lawsuit. Well, if they file the lawsuit and then it gets dismissed, it's as if that lawsuit was never filed. And so all that time is ticking and they may be out of time. They may not. They could refile it. There's a lot of factors that go into it. So you want to be vigilant on that if it's been dismissed without prejudice, and, maybe check the court docket every now and again, or see if they'd have to reserve you. So you would receive notice of it. But those are things to be, cognizant of. So, but awesome. I'm glad to hear that was successful. Damien says, "Hi, John. I tried again to settle for a lower amount before I go to trial. At the end of the month, the rep said they couldn't settle because they don't own the debt. The medical provider does. I found this very curious, because if that's the case, shouldn't the medical provider be taking me to court and not the collection agency? The whole thing is very confusing." Yeah, that's a problem. If they're saying that they can't settle because they don't own the debt, then they don't have standing to prove, to be able to be there. The standing requirement means that they are the right person to be bringing the lawsuit. And junk debt buyers allege they have standing because they're saying they purchased the debt. If it's something like this, a medical debt, if they've just assigned it out to like some third-party debt collector to do the phone calls, they should not be able to keep or maintain the lawsuit. And it would be a defense for sure that you could bring in the underlying, as far as their defense. That's the first thing you need to fight, is to bring the claim. One way you could cross-examine them on that issue, the fact that they said that, you may want to find out who the collector was that told you that they don't own the debt, and that could be used against them. Absolutely, 100%. So, all right, let's see. Richard says, "Is it okay to delete Cash App account before filing for bankruptcy?" So there's a part of the bankruptcy documents that have to be filed. One is called the Statement of Financial Affairs, which is, we call it the SOFA for short. One of the questions in there is going to ask you if you've closed any financial accounts in the last 12 months. And if you did, you have to, disclose the balance. You have to disclose if there was a balance when you closed it, what happened to that money. So you can delete the Cash App. You're still going to have to disclose that you closed that account out in the prior 12 months prior to filing for bankruptcy. All right. Ransom here says, "I have an installment plan pending with the IRS. I just lost my W-2 job yesterday. Still self-employed, so sorry to hear about that. What happens if I send an offer in compromise with the installment plan pending?" And my only little asterisk here, I'm not an expert by any means in offering compromises with the IRS, but I have definitely prepared them. So what'll happen is, if you send, if you have your offer in compromise submitted, they're going to have you verify income, things like that. They don't just take your word for it. I know the forms are lengthy, but you're going to have to provide some kind of proof of income. And so if the offer in compromise, if you're also, you sign those under penalty of perjury. So if your situation has changed, you're going to need to update the documents in order to be able to get that offer in compromise approved. Because a lot of it, their decision is going to be based upon income, expenses, debts, things like that you have. So you got to make sure that they're accurate. All right, let's see. Max says, "Got the judge to send me versus Chase to arbitration. Chase is dragging their feet for months. Can I tell the judge and get it dismissed?" Yeah. So, that's what the approach I generally take is that if you have filed a motion to compel private arbitration And if the court doesn't dismiss the case, if they just stay the case and says, okay, parties go do it. The one thing I do, I think that a responsible and a good approach is to go back to the court and file a motion to dismiss without prejudice or with prejudice, saying, look, judge, you ordered the parties to go to arbitration. They're the ones with the claim against me, and they're not doing it. And so it shouldn't just sit out here forever like this. Go back to your arbitration clause and look. Sometimes, if you're lucky, there'll be language in there that literally says the party who has the claims against the other party is the one who initiates the arbitration. And I brought this up before because it just doesn't make sense that the party who's being sued would be the one to initiate arbitration. That would be the equivalent of you going down to the local courthouse and filing a lawsuit against yourself. It just doesn't make sense. If you're not asserting claims against Chase, it's Chase who needs to initiate that. You're just invoking the arbitration clause of saying, hey, I don't want to litigate in this forum. Let's go over there to the private arbitration forum and have it dealt with that way. So that's what I would recommend, is if the court said, okay, you know what, go do the private arbitration thing, and then Chase is not doing it, I would file a motion to dismiss with prejudice. Make sure you explain what the court ordered you to do, that, to go through the arbitration process. And then if they don't, yeah, that's exactly what I do. I would push them and see if you can get the court to, it'll either make them, go through the arbitration, or it will, you'll get the case dismissed. JJ says there's a follow-up. Can a judge deny your request for arbitration? At the end of the day, it's their world. I always say that we just work at it. Judges can do really anything they want. The question is, if they deny it, what are your rights? If they deny it, you can usually appeal in a ruling like that and get a higher court to take a look at it. Or often what I'll do is I'll file a motion to reconsider, or sometimes there's like a motion to essentially be a motion to reconsider in most jurisdictions. You could request that to say, look, this is their document. It's not me trying to make something up. This is their own contract. I'm just asking that it be enforced. And Max says, but the judge said I had to start the arbitration, and you did. Okay. So, if you started the arbitration and they're just not doing anything, I guess what you're going to have to be dealing with there is if the arbitration process is started, you may need to bring this before the private arbitrator if they're the ones who aren't, if Chase isn't engaging in it like they should, to have a ruling entered in your favor. So it could be that the court's not even going to deal with it if you actually have the arbitration process going. All right, let's do one more question. We'll finish with Al here tonight. Arbitration versus declarations. Is there a difference when a junk debt buyer enters them as evidence in a lawsuit? Oh, you're probably meaning affidavits. The answer to that is no. The declaration, affidavits are sworn statements. They usually are notarized. All a notary stamp means is that the person who signed it is who they said they were. So, like if you go before a notary public, you have to show ID so that they know that you're the person who actually signed it. You're seeing a lot of courts, including the federal courts, who are now going to these what we call them unsworn declarations, because it makes it so much easier if you don't have to get something notarized, because particularly for attorneys, even though most of our staff are notaries, it just makes it a lot easier if we can get the client, if I can send it over, they can DocuSign it or whatever it is. So there's really not a huge difference between the two. They're both under penalty of perjury. They're both going to cause problems if you're lying in there. So either way. So, all right. Hey, JJ, thank you for supporting the channel. I am not going to lie. I've got to cut this short tonight. I've got another meeting I've got to run to. But just real quick, just remember again the Consumer Warrior community that we have going on now. And the links in the thing there. We've got this masterclass on how to cross-examine a witness. You're going to get my super secret form on how we do that. And it'll be a big help if you find yourself in getting into a situation where you're actually going to be in court or a deposition. It'll be helpful there. So hopefully that's helpful. We'll get some more videos out here soon. I've kind of had a busy week with everything at work, but we're going to get some good videos. I've got a whole backlog of things I want to do. So we'll get those out soon. But appreciate you checking in. We'll check you next week.